Andelin?
Thank you so much and welcome everyone. Thank you for joining us for this session of Section 3 office hours. These office hours are meant to enhance the 3-day training sessions that were offered in 2021 due to the sustained requests for additional occasions to ask questions. HUD is providing several opportunities to engage with Section 3 subject matter experts via office hours. Today is the third session being provided out of 6. If by chance you did not attend one of the initial 2021 training sessions, we want to encourage you to engage in the course material. We don't have a set agenda for this session. Rather, we are here to assist you. So please ask your Section 3 related questions either verbally or in writing. As Madura said, use the Q&A box for write-in questions or ask to be unmuted through the chat box so that our team can unmute you and we can discuss your questions verbally. All right, as you're typing your questions and asking to be unmuted, let's introduce ourselves. We'll start with my colleague, Carrie Kronberg.
Hi, everyone. I'm Carrie Kronberg with ICF. I delivered, I think, 7 of the trainings that we did last year, so may have met some of you in those. I've been with ICF almost a year and a half, about a year and 5 months. And before that was in state government in Colorado for many years, so implementing Section 3 at the state level and understand the challenges related to that. And then I also worked in local government at the county level in Northern California. And now I'm based in the Portland, Oregon area.
Thank you, Carrie. We also have Les Warner with us today. Les, would you like to hop on?
Sure. Much like Carrie and Andelin, you may have had me in one of the Section 3 trainings. We did a whole series of those. I've been with ICF for, I'm in my 15th year, and before that I spent 20 years at the state level. I remember the early days of Section 3 when folks would go to trainings and they would come out saying, I think I know less about Section 3 than I did when I went in. And I think this training is, we've got a lot of really good information and materials and sample forms. And so hopefully this is really helping people to be able to launch their program and make sure they're going to be in compliance with the new rule.
Awesome. Thank you, Les. And I am Andelin Nesbitt Rodriguez. I've been with ICF for a little under a year. Prior to joining ICF, I was with the City of Columbia in South Carolina. And prior to that, I was boots on the ground working with nonprofits in the area. I'm in Columbia, South Carolina. So happy to be here and happy to answer all of your Section 3 questions. Let's get started. Okay. I don't see any questions in Q&A so far. Madura, do we have anyone lined up?
Not just yet, but I think soon we will.
Okay, great. So we'll just kind of go through a question or two, ones that we've gotten over and over in these, so we know that there's a need. What if the city has a program like owner-occupied rehab? It's one program that services different houses separately. There's a $20,000 per limit home rehab limit. It's all funded under one program. And that program is funded at $250,000, but each home has a separate purchase agreement and construction contract. Would this trigger Section 3? Carrie, do you want to take that or you want me to continue?
Sorry, go ahead. I was reading some of the questions coming in.
Oh yeah, now I see questions, but we'll go ahead and answer this quickly and then we'll get to the questions. For this one, this would actually not trigger Section 3 because each home has a separate agreement and construction contract. So for folks that have maybe a CDBG program, owner-occupied rehab, and the program is, over the $200,000 threshold there, but each home is counted separately through separate purchase agreements and construction contracts, that does not trigger Section 3. So hopefully that's a sigh of relief there. All right, let's get into some of the questions that are coming in. Carrie, did you have one for us?
Sure. So one that I saw is the HUD sample plan talks about giving preferences for Section 3 businesses. What kind of preferences is HUD contemplating? And so I'll note that, you know, with Section 3, you want to make sure you provide opportunities to Section 3 businesses to, you know, compete in competitive procurements for work or be hired as on a Section 3 covered project. The rule does say that there's nothing that requires you to hire a Section 3 business if they can't meet the terms of the contract, or they can't, or a Section 3 worker, for instance, if they aren't capable of doing the job. So as for specific preferences, Andela and I can think about that for a minute, but if you have any suggestions, you know, I think that's something that I would say when I was an implementer, is, you know, all things equal, you would want to choose the Section 3 business over the regular business because they will help you achieve your Section 3 goals. Anything to add to that, Andalyn?
No, that's exactly what I was going to say. Choosing a Section 3 business concern really does help you towards your benchmarks, towards the 25% Section 3 labor hour benchmark and the 5% targeted Section 3 labor hour benchmark, because people who work for a Section 3 business concern are automatically considered Section 3 and targeted Section 3 workers. So it really is helpful to have those Section 3 business concerns on board.
Okay, so another one, can we take credit for Youth Conservation Corps for all housing projects? So I'll admit I'm not super familiar with Youth Conservation Corps, but it is, you know, the Youth Build program. Any participant in Youth Build or any Section 3 business that hires, right, Youth Build participants, you can get credit for, they are Section 3 workers and targeted Section 3 workers. So I'm not sure how that relates to Youth Conservation Corps. I don't know if that's something you're familiar with, Andalyn.
Not.
Okay. But Youth Build is something specific funded by the Department of Labor. And it's kind of an apprentice program for youth that have, you know, dropped out of high school and then meet one of several other criteria.
Mentor, do we have anyone who wants to come off and talk? This should be interactive as much as possible. We know Les is answering the written questions, but we'd like to hear from some of you guys.
Right now, we don't have anybody who would like to come off of mute, but I can go ahead and read a few of the questions if you'd like that have come into the chat box.
Okay.
Okay, this is from Stephanie Wanza. Does Section 3 apply to housing voucher programs, especially with the construction of a new property?
So the Section 3 was it public housing financial assistance has a specific definition in the notice, and housing choice vouchers are not covered public housing financial assistance. So they are in the rule, development assistance provided pursuant to Section 5 of the 1937 Act, operations and management assistance, development, modernization, and management assistance provided pursuant to Section 9D of the 1937 Act, and the entirety of a mixed finance development project is defined in 24 CFR 905-604, whether fully or partially funded through that. So, you know, standard vouchered programs are not covered financial assistance under public housing. So make sure you refer to that. You know, I think applicability with regulations and understanding definitions is really critical, right? So what are we talking about when we say public housing financial assistance? It is specifically defined with reference to statutes and regulations.
Right. And if you're asking about the voucher program specifically, remember that there has to be a labor component. My understanding is that vouchers are for, I'm more on the HCD side, but vouchers are more a monetary thing and don't include a labor component, is my understanding. So for that reason also, it wouldn't be applicable.
Yeah, you might have, you know, some project-based vouchers committed to a project under development, but those by themselves wouldn't trigger Section 3.
All right. Madura, anybody in the queue?
Not verbally yet, but I can read another one. This is from, and I apologize if I mispronounce your name. This is from Milestine Tatum. Which department or personnel within the Housing Authority should take the lead with implementing Section 3?
So I'll take that, and you can add anything if you want, Andolyn. So that's really up to the Housing Authority to decide. It's a recommendation that, you know, in implementing Section 3, that you designate someone, you know, a Section 3 coordinator, whatever you want to call them, but someone who can kind of take ownership, really learn the regs and, you know, educate other, you know, their colleagues, well, kind of take the lead if you decide to develop a Section 3 plan. They can take the lead on that, but there's no, you know, it should be, you know, this position within a housing authority. There's not that level of guidance from HUD. So it's whatever would make sense for the housing authority on the right person to designate. You might want someone with a, you know, who understands construction contracting, right? You might, you know, want to think about the right background and skills, but there's no specific guidance, like I said.
Right. And just to reiterate, I'm going to say this just because we've gotten this question in this similar question in other office hours and trainings. The onus to fulfill the Section 3 requirements falls on the grantee. So I know this was not, it's tangential to the question, but it definitely has to be someone spearheading the whole thing from the housing authorities team, because ultimately the responsibility will be on the housing authority or the housing community development department.
Okay, I see another question. It looks like Les took it in writing, but someone was asking about a template form for workers to fill out to document their income and address. So there are sample certification forms that were developed as part of that training, and they should be available. I believe those are available maybe as part of the guidebook. That is, I think that came out a month or so ago. Time flies these days. But there are sample forms. You know, you do want to modify those, make sure they make sense for you. And remember just that people don't have to write their exact income, right? They just have to certify that they're at a certain level or below. You know, you could modify this and, you know, indicate the income limit and they could say yes or no, I'm above, you know, I earn less than this annually, and that would be sufficient for documenting their income.
Carrie, I don't know if you might want to try to take Katrina's question about discrepancies. I suspect it's not a screen that's related to Section 3 if it's asking about Section 3 residents, but I'm not sure.
Okay, yeah, so there is a question that says there are some differences between the 24 CFR 75.25 regulation and the IDIS Section 3 screens. For instance, multiple categories such as childcare were split, list Section 3 residents instead of workers. Can we address these discrepancies? So I think we could flag those to HUD, but what I've seen of the IDIS screens is that they did track pretty closely with what was listed in the rule. Yeah, we have some screenshots here, and then you were able to select other. So I'm not sure what you're seeing. So yeah, so this one is the screen where you're doing a closeout activity completion, and they ask there where it's highlighted, is this activity subject to Section 3? And then I think if it is, you'll have additional reporting to do on your benchmarks. So how many hours, what were the total labor hours on the project. I don't know if you can go to the next, if that's on the next screen, Andolin. So yeah, the total labor hours, the targeted Section 3 worker hours, and then the Section 3 worker hours, and then it automatically calculates the percentage for you. Then if you don't meet the benchmarks, if you do meet the benchmarks, the rest of it goes away. So you don't have to report on the qualitative efforts. But if you don't meet the 25% Section 3 worker hours and 5% targeted Section 3 worker hours, then you have to report on qualitative efforts, which I think we had a screenshot of maybe on the next slide. There we go. So the nature of the agency efforts. And so this is how you tried to meet the Section 3 benchmarks. So even if you don't meet them, you can still be in compliance by, having documentation in your files. You don't have to submit it as part of this closeout, but having documentation in your files and being able to report to HUD, of your efforts to comply with Section 3.
I see a question that actually came into the chat. Is there a replacement system for Spears? And that's a good question. You'll now be reporting through IDIS.
Right, or
so
DRGR, or I think the housing authority system is going, I think they're going to have a separate reporting
They
portal
are.
that to my knowledge isn't yet up and running, but housing authorities don't have to report until, was it 60 days after the end of their fiscal year that starts after July 1st of last year. So at the earliest, housing authorities will have to be reporting in September of this year. But if your fiscal year starts March 1st, you won't be reporting till, I guess it wouldn't be March, it would be April 1st. You wouldn't be reporting until a year from now.
Right. All right, Medora, do we have anyone in the queue?
Yep, we have Michael Muffley, who has a few questions that he will ask. So Michael, I'm about to unmute you. Michael, you've been unmuted.
Hi, thank you so much. I have a couple questions. The first has to do with standard terms and conditions that HUD requires be added to all the contracts. We've reached out to our regional office to ask them about when the terms and conditions will be updated so that we can include them as part of our requests for proposals and part of our contracts. And they really can't provide us with any information. So I'm just wondering if do we have a deadline by when the terms and conditions are going to be updated so that we can make sure that we're including the things that HUD wants us to include?
We do not. I don't have any update on that or specific clauses.
So under the old rule, I think there was some specific, a specific Section 3 clause that needed to be included in contracts. And from, I think what we've trained and understood is there isn't specific language that's required. So you probably want to work with, your procurement and legal folks to, take a look at the requirements and write something yourself. If it's on the housing authority side and they have specific templates, that's a little bit harder for us to speak to. Because I know, in some of the work that I did where we had public housing financial assistance in projects that we funded with also, CPD funds, there were sometimes specific templates to use. But as far as I know, at least on the CPD side, there isn't a Section 3 clause like there was for the old rule.
Okay, it's unfortunate that we weren't told that before because we've been waiting and we could have been working around that issue. My next question has to do with the reporting, and you kind of said that there's going to be a separate reporting portal for PHAs, but it hasn't been developed yet. And my question was, we've been trying to work with LPC Tracker because they have a Section 3 module that is included with the wage compliance monitoring. They claim that they're working with HUD. They've worked with HUD to develop the Section 3 module, but they're as far as they can go because they still don't know what the report's supposed to look like. And, you know, we're one of the housing authorities that will have to start reporting or start, you know, monitoring to report April 1st, but yet we still don't know what the report is going to look like. So do we have an idea of when HUD is going to have a model of what the report is going to look like?
Yeah. I think that's one that we can take to HUD because as TA providers, we're not privy to their you know, internal workings and you know, deadlines. So we can take that to HUD and ask if they have an update on when that's going to be out. I think they know, you know, so I think the earliest anyone from a PHA would have to report would be September 1st, August 31st, around that time. So if that's you, then I mean, they know that, right? They know that people are going to have to be able to report starting at the end of the summer. But other than that, we don't know. I think that, you know, what you can do is, you know, that what you have to report on, you know, what the requirements are. It's, you know, total labor hours, Section 3 worker hours, and targeted Section 3 worker hours. From what I understand and what we did in the training is, even though you're reporting on a fiscal year basis, and that's when you're, you know, trying to meet, you have to meet the benchmarks if you are achieving compliance in that way over that fiscal year. I believe it's still on a project by project basis that you're reporting into the system, but I wish I had a better answer on that, but we can definitely let HUD know that folks are looking for an update on when that will be available.
Okay, and I guess kind of along that question, assuming that you have a situation where you're not meeting the benchmark and you're going to be showing qualitative efforts, obviously at that point, then you are going to probably have to provide some sort of documentation that qualitative efforts were met rather than just checking a box that, yes, we've been monitoring qualitative efforts.
Right.
So
I think for monitoring you would. So when you're reporting on it into the system, everything we've heard and in our discussions with them is, you know, there's not documentation required. You are checking a box, but then if HUD comes to monitor you, you have to have something to back it up.
Okay. And I guess my last question kind of goes around contracts that might have been pre new rule, but have options that can be exercised. And so the contract, you know, may have had a 2-year term that started in June of 2020. So it would expire, that's pre the rule, and it would expire in June of 2022. But there is an option to extend for an additional year or additional 2 years. Do we treat those options as new contracts that would be subject to the new rule, or would they still relate to the old rule?
So if it was CPD, which it probably isn't for you,
No.
it's about when the funding is committed. But for PHAs, I think it's about anything that occurs during the fiscal year that is, and this gets tricky, right? Because you have your contract issue of you signed a contract that didn't have it. Sorry, I'm thinking out loud.
Yeah, no, okay.
So I think if I were you, I would add it to that option, especially if you're adding money.
Okay. So you're saying that I understand what you're saying for the option perspective, but you're saying that from a PHA perspective, from a housing authority perspective, it does for a legacy project, it doesn't matter when the funds were committed. It only matters if it happened within the fiscal year. So if we had a project where funds were committed pre November 1st, 2020, it
No,
was,
I don't think that's right, because you can't go back in time, and I think HUD understands it. So yeah, and this shows that it's not specific to CPD funds. So I
okay,
think if
all
the
right. Just wanted
contract
to make
was
sure, because I
executed,
didn't think it was. So,
yeah,
all right, thank you. I don't have any more questions
yeah,
right now.
I think November 30th, this is one thing. November 30th, 2020 is the beginning of time for Part
Yeah.
75, right? There is nothing before that.
But we are saying that when the extension is signed,
Right.
that is no longer a legacy project. It's a new
Understood.
rule. Okay, perfect. Perfect. All right. Thank you so much.
Thank you.
Thanks for coming on. Okay. Madura, do we have another?
Yep, we have Trina Wright in the queue. Trina, I am about to unmute you.
Hi, my question is, I work at a PHA and we are in a joint venture with the local municipality on a project. So we both have the same reporting requirement, although they're looking from it from a CDBG point of view, and we're a housing authority, of course. But when we're reporting that data, who should report the data, so it won't be double counted in any kind of way? What are the rules in regards to reporting when we're in a situation like that?
I can take it, or you can.
Okay.
Andolyn, if you want.
If you go ahead, I'm looking for the slide on.
Sure. Okay. So it's both are responsible for reporting, but as part of that reporting, you're supposed to include other funding sources that could have triggered Section 3 so that they can reconcile. So I think they understand that there are tons of projects out there. There's lots of projects that have multiple sources of HCD funding. When I worked in state government, we joint funded things all the time with HUD funds with local governments. So both are responsible. You just have to, include the information that there is other funding in this project that triggers Section 3 from another source, and they'll be reporting on it as well.
So the data it'll be duplicate because it's duplicate efforts. Oh, we just letting us. Okay, that makes it easier for me to understand it. Okay.
So for
that's
you,
it for me right now, I think.
Okay. I just want to clarify that for you as a PHA, you'll follow subpart B of Part 75 when it comes to reporting. The local municipality, if that's HCD funds in the same project, will follow either subpart B or C for reporting. So for continuity, just, it's a best practice that both of you follow subpart B. It makes it easier.
Right.
Okay.
That's,
also, I do have one last question. Oh, wait a minute. Oh, well, will I get access to your to all this information I'm able to look at on the screen, your slides, or no?
I think these slides will be posted to the HUD Exchange if they're not already.
Okay.
Go ahead, Andolyn.
I think that might be an important thing to mention here. So I get the sense that a lot of today's participants have not had the opportunity to go through the training series. And so the slides that we're pulling up are part of the 3-session training series, and they should be posted, I believe, at this point on the HUD Exchange. And I think for a lot of the questions that you're asking, the sort of additional level of detail and things like the sample forms that you're looking for would all be included in that. And those sessions, not only are, I believe, the slides available, but there are recordings of those sessions, which I think will be really helpful for folks if they have not had an opportunity to participate in those. Carrie and Andolyn, I've got a couple here that I think would probably be a lot easier to try to deal with as a verbal, just because of what all needs to be covered. So we've had a number of questions about spears and also having to go back in time and try to collect data. So I think helping folks revisit of, legacy versus transition would be helpful for folks to kind of grasp on what they're going to have to be able to report and where and when.
And I'll just note before we get into that, I just posted the link to the HUD Exchange page that does have a recording of the Section 3 training, all of the slides, transcript, the tools that were introduced as part of that training. So in the chat, there's a link to that page.
You beat me to it. I literally just copied it. And Trina, we didn't get to say bye, but thank you so much for coming on. And
Thank you. Okay.
thank you.
Great.
Okay, so do you want to go back to the legacy project slides and transition? So HUD did consider when they were, they realized that there's a transition period and that's tough, and that's partly why, the rule was published in September of 2020. We had a couple months to a month and a half or so, 2 months to, adjust, and it became effective November 30th, but full compliance wasn't until July 1st of last year. I can't believe it's almost been a year. So if your funds were committed between, this is the transition period slide. So if you committed funds to a project between November 30th, 2020, so the beginning of time, and July 1st, 2021, you follow the final rule under Part 75. So that's the new rule. The old one was Part 135. You need to maintain records, but there's not a reporting requirement in SPEARS or in IDIS for that period of time. So that's something where, again, if HUD comes to monitor, they will want to see that you were integrating and starting to comply with the new rule, but reporting isn't required. And just, there was additional clarification put out by the Office of Block Grant Assistance, so that's the CDBG office, that, if you did execute a contract in that transition period, but it remained open starting July 1st, 2021, then they were going to expect reporting based on that. So, and that highlights another, a big change in the Section 3 rule is that enforcement has switched from the Office of Fair Housing and Equal Opportunity to the program offices. So that's, you'll be working with your HUD rep, in the CPD office locally, but Office of Block Grant Assistance now has oversight for Section 3 over CDBG and related programs. Office of Affordable Housing Programs has oversight for home, HTF, home ARP, et cetera. So it's a bit of a shift. I think, largely good because these are folks that, understand the programs and the complications, and also, being your HUD field rep, it's someone that you work with regularly, and should have an open dialogue with to get assistance and support. So, okay, and then the legacy projects, we did show that when we were talking a little bit ago, but anything that was executed prior to November 30th, 2020, the requirement is you adhere to the old rule, 24 CFR Part 35. So again, maintain records if you're monitored, but there's no reporting requirement in SPEARS. So as far as I know, SPEARS has been mothballed, right? It's
Yeah. Yeah, it's deactivated.
Right.
Yeah. All right. Are we ready to take another question?
Sure. Is there anyone that wants to talk to us?
We've got 2 in the queue. The first is Dina Dennis. I'm going to unmute you now. Dina, you've been unmuted.
Thank you. I have 2 quick questions, and you may have covered this way back when we were talking about the project-based vouchers. But I understand, so our initial solicitation going out to developers for project-based vouchers does not trigger Section 3 because they are requesting vouchers for their project. Right. However, we are giving project-based vouchers for new construction. So does would Section 3 be triggered on the construction project of that, or not at all because it's project-based vouchers?
Depending on it's how it's funded.
Okay.
So yeah, so if it's probably quite likely that there is some other HUD funding
Right.
source, maybe CPD, but that would be up to, you know, the grantee working
Yeah.
with HUD for that.
Okay.
So, but the vouchers don't trigger Section 3 by themselves.
Vouchers do not at all. Okay, thank you. And then my other quick question on the Section 3 worker certification form and that income table, is that going to be changed every year when HUD releases the new income limits, or are these
So
like set?
this is a sample, and I think, you know, in looking at it and thinking about if the adjustments I might make to it is I might so this is for you to take and update and use for yourselves. So I might get rid of those ranges
Right.
because say, you know, your income limit is $45,000 a year. Well, if, you know, if you check 40,000 to 50,000, that doesn't tell you really whether someone is above or below. So I
Right.
think I would probably say, here's the income limit.
Okay.
I'm above it, I'm below it. So
Right.
these are just samples to get you
Okay.
started, and you can adjust them as makes sense for you.
Thank you. Yeah, that the way you said it made much more sense. And it seemed like last year they were way late in issuing those income limits. And I just kept thinking, well, maybe it was COVID. But is that typical that they're not issued till late April, early May?
I was a CPD person, and they, you know, so looking for home income
Right.
limits, and it seemed like those changed a lot. And yeah, I would suspect COVID had an impact. I know a couple of years ago, right? We had that big shutdown for however many weeks,
Right.
and that caused delay. So it's sometimes it's a little hard to predict when they'll come out. I think FMRs are pretty consistent as always being effective at the beginning of the federal fiscal year, but income limits, it does change a little bit.
So when the way I use my income limits now for the Section 3 new hire and now changing over to the labor hours, it's whatever was advertised in the solicitation of that project, or do we change their document in the middle of a project because the income limits have changed?
That's a good question. So it would be, I think you might want to update it because they do become effective. I think it's 30 days after they're published. So it gives you a little bit of time to update it. So I think that is something that you would want to track.
Okay, so if they were Section 3 at the beginning of the project, there is a chance with the income limit tables changing that they are not, or it goes back to the past 3 years and we use that past 3-year rule.
It's about the time that they were certified. So if you have a worker, so it would only
Okay.
be for new workers, right? If you're hiring
Okay.
someone else later on in the project and it's changed, but at the time that they were certified, or when they were hired, right? So
Right.
in the past 5 years, but for now back to November 30th, 2020, it's about, you know, at the time that we're looking at their income to qualify them as low income at that point. So we want people's income to go up, right?
Right.
That's part of the point of Section 3. So this change about for how long people can count as Section 3 workers is, you know, is recognizing, hey, this is a good thing that we're giving people economic opportunities and they're, you know, developing skills and are worth more, you know, on the job market.
Right.
So once
Thank
they're
you so
certified,
much. That was very helpful.
so once they're certified for 5 years, right?
Great.
Okay, thank you so much.
Thank you.
Bye-bye. Right.
I have a couple here that would probably be better to try to deal with verbally. And I can maybe get this one started and you guys can add in if you like. we had a question about they're describing a project that has one lot, and they are going to be building 8 single-family homes. I would presume from this that this land is going to be subdivided and that these are going to then be sold. And they're describing that 4 of the houses have HUD funds, but the other are not. And so question about, if the HUD assistance is over $200,000, are they counting Section 3? So the thing that's important here is to look at that definition of a project. And so somewhere we've got, I think in maybe day 1, and I know Andelin, you have that wonderful cheat sheet that you developed. It's actually slide 30, I believe, on day 1. So we're looking when they are under common ownership, management, and financing. So in this scenario, if we're developing, sounds like a little subdivision, these are going to be in the development phase, going to be under one ownership, management, and the funding was provided to build 8 projects. There's a mix of funding in that. So that would be one project. So then we look at the cumulative dollars. If we're talking HCD funds, we have a threshold that's based on exceeding $200,000. So if our HCD funds exceed that, then this is a Section 3 project, and we're going to be collecting all of the needed information for the overall project. If we had this same, maybe we have this same site that was subdivided into 8 lots, and we had applicants who were applying for assistance to be able to build on one of those sites. So in that case, we would have individual owners of these 8 different lots and separate financing. And so those could be 8 projects. So we really have to apply this definition of a project to determine, what all are we including in this project, and then all of the sources of funding that are part of that overall project are used as part of that evaluation of whether we have triggered Section 3 or not. You guys want to add anything to that?
You did a great job of explaining it.
Thank you.
All
Any
right.
others that you wanted to cover verbally?
I have one that I've answered a couple of times and it keeps coming back. So I'm not sure if there's something wrong with the system. So we've had a question about, do youth build participants have to be current participants, or can they be past youth build participants? And the answer here is that they have to be current participants. So the fact that they, a few years ago completed the youth build program does not then continue to qualify them. So we're trying to link where we have current youth build participants that then are going to be able to be hired for these jobs. So that's the answer on that. Let's see. I think that maybe the two of you can talk a little bit about this issue of the 5-year look back period and revisit that, because it looks like we have 2 questions that are related to that.
Okay. Andelin, can you go to that slide where we're talking about defining, let's say, a Section 3 worker? There we go. So this is I would add as a caveat to what Les said, at the time that the person was certified, right, or hired within the past 5 years or after November 30th, 2020. So a Section 3 worker is anyone who currently fits or when hired within the past 5 years met at least one of these categories. So low or very low income worker, employed by a Section 3 business concern, or were a youth build participant. So once they're certified, then they keep that certification for 5 years, even if they're no longer a youth build participant or are no longer low income or very low income. And then, for a targeted Section 3 worker, we can go to that. The definition is a little bit different for public housing versus, housing community development assistance. So there, the difference is someone who is a resident of public housing or Section 8 assisted housing, et cetera, but that's all, still currently fit or when hired fit one of these categories within the past 5 years, back to the beginning of time, November 30th, 2020. So, and then for HCD, it's about the difference for a targeted Section 3 worker is about where they were living in the service area or neighborhood of the project. So that's, do they live near the project site? And because part of Section 3 also is, it's to provide economic opportunities, but also to keep HUD funds local and to benefit the residents of the areas where they serve, or where the project is, excuse me. So go ahead, Endelyn.
And I apologize, Carrie. I just want to note that, because I saw a couple of questions, a targeted Section 3 worker is a Section 3 worker. So if you're counting someone as a targeted Section 3 worker in that formula, you're also still going to count them as a Section 3 worker. It seems like you're counting them twice, but really the formulas don't have a lot to do with each other. They're not the same formula. So you can count them as a targeted Section 3 worker and a Section 3 worker. And yes, as you can see here, if a Section 3 worker is someone who either is, the low or very low income, but also could be employed by a Section 3 business concern or youth build participant. And a targeted Section 3 worker, whether it's for public housing or HCD, also employed by a Section 3 business. So if someone is employed by a Section 3 business concern, they're automatically a Section 3 worker and a targeted Section 3 worker. So I know that, and also if they're a youth build participant, the same thing there. I saw that come up in the questions after we answered another question. One other question, I keep saying the word question, one other question that came up in the Q&A was if someone, and I'm trying to get back to it, if someone is certified as a Section 3 worker or targeted Section 3 worker for 5 years, do we need to retain that Section 3, or do we need to recertify them every year during the 5 years? The answer to that is no. They're already certified, and that certification lasts for 3 years. However, when you're collecting the Section 3 business information and justifying the calculation that you'll do every year, so they'll still go into your year 2, 3, 4 calculation when you do the 25% and 5% formula to get the benchmarks, to meet your benchmarks. When you're calculating that, your backup documentation still needs to include the certifications for everyone that you used in that formula. So in year 2 and 3 and 4, you're still going to use that certification that you received in year 1. So for me, I would duplicate that in my files and have that certification, even though they were certified in year 1, I would have that same 3 and 4 documentation. Oh, I hope that makes sense. I hope I was being clear there.
I think that would, make things easier, because if HUD comes to monitor you for fiscal year 3, you don't want to have to dig back to year 1's records to find all of the certification forms for that person that you counted, right? So,
and I think it's important to remind folks that they don't have to stay income eligible over time, which is the good news. That's why we have this 5-year period where, we're hoping for sustainable employment and that they actually will see their income rise over time. And that's one of the advantages if you're working in a labor union state where you perhaps have some apprenticeship programs where folks are coming in at a lower rate. that they would still, after they then move into a higher rate position, would still be able to be counted as a qualifying worker if at the point that they were hired, they did qualify.
Thank you. We just got another question that it's pertinent to, so we're going to go ahead and address that one. So the certification lasts for 5 years, or can they go back 5 years if they fit the income limits within the past 5 years? It's a great question. The answer is both. The certification lasts for 5 years, and you can go back to a look back period that in theory is a 5-year look back period. But remember, the beginning of time was November of 2020, right? So we cannot, I think it's November 30th, 2020. We cannot go back farther than November 30th, 2020. So right now we have less than a 2-year window for a look back because you just can't look back farther than November 30th, 2020.
Right.
As time moves on, you know, we'll cover the 5 years. You can look back 5 years, but the certification would last from 5 years from when you certified them.
Right. And that would be typically about when they were hired, right? So they're the contractor that is counting them as a Section 3 worker hired them in January of 2021. They were low income at that time, and then they could count them for 5 years from that moment into towards the Section 3 worker hours.
Excellent point, Carrie. They have to have been hired. They have to have been working for that same employer for that whole time, for the look back and for the 5-year look forward. As long as they're working for the same employer, they remain certified. All right. Madura, do we have anyone in the queue?
Sorry about that. Just changed my mute button. We have 2 people in the queue. This is Steve and this is Steve Tama. I'm going to unmute you now.
Hello.
Hi, Steve.
Okay, I saw your Section 3 self-certification form. That's really nice. And my question is about states that have salary band laws. And I think you may reference it in the third question where it says the grantee shall confirm that there are state and local laws that prohibit this question. So if we have a salary band law like we do in New York, is it basically we can't ask the worker how much they make or how much they made over the course of a year? Therefore, we can't verify if they're a Section 3 worker.
I guess you couldn't verify them based on income. That's right. So yes, but I think the bigger answer to the question, and I'm not familiar with New York's law, but is Section 3 is subordinate to all other federal, state, and local laws. So if you have a law that conflicts with your ability to document or comply with Section 3, then Section 3 is subordinate to it. And looks like Les wants to say something.
I have a solution here.
I had the solution.
So, I mean, this is a self-certification form if we're trying to document eligibility by the worker, but because our income is based on an individual salary rather than, you know, we need to go back to household or family like we're used to doing, the employer is also able to do that certification. So the employer knows what salary those workers are being paid, has access to that, and so they can review the payroll for this project and compare that to the income limits for an individual worker and be able to then say, okay, these workers on this project are qualified as a Section 3 worker based on income, and then be able to track the number of hours worked by them. So, I mean, that's actually, I think, one of the things that on a project by project basis, it may even just be easier to say, you know, the employer is already going to be reporting on, you know, hours worked by workers, those sorts of things, since they have access to what the salary is that's being paid to this worker. it may be that some folks will say we're generally not going to go to workers with a self-certification form that we need to explain to them, but simply we will ask the employer to right up front, and that's one of the things we talked about with, at contracting or at the point that that contract was in place, asking them to identify which of the workers are going to qualify based on income. And in that way, then the employer just continues to track and report the number of labor hours worked by each of those qualifying employees, and it's kind of handled pretty efficiently without going to each individual worker. So that's the good news.
Thank you, Les. I get a little excited. This is one of my favorite parts of this, the changes to the final rule is that you can handle this without even getting the worker involved, which streamlines just a ton. So
You're
absolutely.
asking one person rather than each individual worker. And because it's, as Les said, based on that individual income, not the family, right? You're not looking at the whole household's income, just what that worker is making as a one-person household.
Working for that employer.
Right.
And additionally, on projects that are a Davis-Bacon project, you already have certified payrolls that are coming to you. So you have some backup documentation that you could double check if you wanted to what's being reported to you. So I do think they made quite a bit of effort as they laid out these requirements to try to make this a little more efficient to be able to do.
So yes, we do on Davis-Bacon jobs, we do collect the payroll, and the payroll we can see what the worker is making, and based on that, we could do a projection over the course of the year. The thing is, what if they have another job? We can't ask if they have any other income.
We have raised that question because that certainly is a possibility. My understanding, and Carrie or Andelin, my understanding is that this can be done by the employer based on that worker's income. And you'll see it says from that employer. So you are not really tasked with going further. And I think all of us as administrators automatically are thinking, well, we should ask more questions and try to track down those additional items. But one of the options here is that employer certification based on the worker's income from that employer. So that really simplifies things.
And we don't have to go any further. Basically, we got the payroll, we got the employer verifying it for us. We don't have to do anything else except track their hours.
Right.
Correct.
Right.
Well, that's good news.
Yeah.
I think some folks will actually probably add some kind of a form that they ask the employer. So up front, identifying which of their workers qualify, and then, based on whatever your reporting period is, asking them to show for those employees what their, if they were, you could add that to the weekly certified payroll and simply ask them to tabulate for each of those Section 3 workers what, for that payroll, but it could also be as part of your, quarterly reporting, or simply at the end where the employer is going to list the qualifying workers, give you the total hours that they worked, and you would have the backup documentation from the certified payrolls in that case for a Davis-Bacon project to be able to, do a little sampling and double checking to see that that appears to be correct.
That's really good news compared to what I have been hearing.
Great. Great.
Any other questions while you've got us?
Yes, actually, it was my understanding in the preamble of the rule that all a contractor has to do is report the hours of their workers on site. We can't force them to comply with this rule. Is that your understanding? Like if we can't put in our bids, you have to have a Section 3 plan or provide so many X amount of Section 3 hours. It was my understanding that the contractors, all they have to do is provide hours. And if they do that, we can't really tell them they have to go any further than that. Is that your understanding as well, or am I incorrect?
Well, I think you can, pass along some of the requirements that they, try to hire Section 3 workers and targeted Section 3 workers, but then they would be reporting just on the workers that are working on that project as well. So when you say on site, I guess that's how I'm interpreting that.
On site meaning the workers on that job. Yes, that's what I mean.
Yeah.
So you're saying we can ask them to do that report whether they are or aren't.
Right.
Okay.
I think that you need to. Yeah.
Yeah. And you need to require them. You have to pass along, even though there isn't language drafted, it needs to be part of the contract with the contractor that, you need to report on this and make some efforts.
Carrie, I'll just add one thing to that. I think one of the options that the rule doesn't say you must do, but one of the options would certainly be if your procurement process allowed you to consider whether it was a responsive bid based on their provision of information about, total Section 3 and targeted Section 3 hours that they were projecting based on their workforce or the subs that they were bringing in. And that's one of the things within the training series that we talk a little bit about. If that's something you could include in your bid requirements, and it could be used as a tool then as part of verifying whether you had a responsive bidder. But we keep reminding folks that you need to keep in mind that you have to follow all federal, state, and local requirements. So if that was not a part of your procurement policy, then that would not be something that you could do. It's not something that's called out as you specifically must do that, but that is a tool.
Okay, yeah, just I'm a purchasing agent here, and I just don't want to ever reject a low responsible bidder because of something I'm wrong about. I just want to be really careful with that. I don't want to boot anyone if I don't have to.
Yeah, not a good idea.
Thank you.
Thank you. All
Who's
right.
next, Medora?
All right, we've got Tracy Odishaw. Tracy, I am unmuting you.
And Medora, after that, we have a number of folks in the Q&A box that are requesting to be unmuted also, so you might look there.
Perfect. Thank you, Les.
Hi. First, I just wanted to let you know that I'm with the city of Tucson. So we are one of those odd entities. We have both the PHA and the PCD side. And my Section 3 coordinator, Becky, so we have to do it for everything. So we do it for both sides of the house. So one thing I want to say, and I'm going to work backwards from some of the comments, talking about the individual certification forms, which we frequently get pushback on. We had our own individual cert forms under the old rule and regs. We had our own, all of our own forms. So we just modified them for this. And so now I'm thinking, well, we don't even have to have that form because we can just ask the employers now, since it's in our area, it's $38,450. And we just put on our form before, we had to have the whole income limit thing. We just put above, boxes above or below $38,450. Now I'm thinking, instead of, because that is so time consuming if you're working on a home LIHTC project. Okay, so obviously I'm on the PCD side here. We've got 26 subcontractors. We've got, a $30 million, LIHTC project going up. Getting all these individual certifications is onerous and was totally onerous under the old rule. So I think we're going to stop that, and we're just going to do employee lists, because that is an incredible amount of work. Then I did want to go back to Michael, one of the first people who spoke up about the HUD forms. And this is going to the PHA side. Sorry, switching over to the PHA, because there is a whole series of general condition forms, which I'm sure think is what he's talking about, the 5370 series and the 5369. There are all these HUD documents that have this 24 CFR Part 135. And I, like Michael, went to my offices and said, when will HUD change these? Oh, that's a good question. We have no idea. And I said, am I allowed to go in and change them all to say Part 75? No, that is illegal. So please send a letter to HUD. Can't somebody go in, do a seek and find? You can quickly change these documents and get them on the websites, because we have to produce all these other documents that contradict the location of the reg, which is really frustrating to have all these forms with the wrong location or wrong CFR citation. So they should really work on that. But I did have a couple of questions about new hires. And so actually not new hires, but this is on both sides of the house. On the PCD side, we can do CDBG funding for FSS, family self-sufficiency, Ross FSS clients. With those dollars, we do job training, job education, a variety of job trainings. We try to meet the needs of what those clients are. And also on the PCD side, we also fund many job training programs, job readiness, for deaf and disabled. We have many PCD funded human services programs where we are doing job training, resume writing and all those activities. But none of those activities are tied directly to the construction or rehab dollars. But how can we count those? Can we count those people? We're giving them training. We're paying for them to go to, like med tech school, and we're paying for training and educational opportunities. How can we count those individuals on our reports? Is that just other efforts?
I think that, yeah, I think it would be considered, those sound like fabulous programs and really, really meaningful qualitative efforts, right? Where you're trying to, you're helping people improve their resumes and giving them skills. You may want to go a step further, I guess, and try to connect those with your projects, right? Encourage them to use the Section 3 opportunity portal, get their resumes in there. So if there is a contractor that's hiring and looking for Section 3 workers, they could find them there. So that might be something you want to do, is just probably go with just a little bit extra and try to connect them with those Section 3 projects. But on the HCD side, it's construction activities, right? The project has to be construction. So job training by itself wouldn't be that.
And I think that's an important point that I think I heard reference to a med tech. So you do need to be able to tie the training back to construction. And so that's an important linkage there.
Okay, so the majority of these people are not getting any training in construction or rehab work. They're going for something different. So I guess we can only mention them perhaps in other efforts. Then related to that, because we have a PHA and then we also have a large Section 8 program, well, large for Tucson, probably not large for big cities. How can we count some of those folks that we hire within our own office? We hire people. We've hired people from, we have people that we have gotten off public housing, because they have worked their way up here, they're, you know, and we've helped give them, you know, training, and they've gotten accounting degrees or certifications, and you know, we have it's really nice to see employees over the years work their way up after being a public housing resident of ours, and to be totally self-sufficient. They're totally on their own. They keep moving their way up in the finance field or whatnot. Also, those people aren't necessarily tied directly to any of the PHA rehab or maintenance work. So is it the same answer? We can't count them. We can only count, maybe note them in other efforts narrative.
Yeah,
The
if
employees.
they are paid with on the public housing side, it's a little bit different, and I'm not as familiar with these funding sources, but if they are paid with anything that qualifies under public housing financial assistance, then you could count them. But if they're, you know, exclusively paid with admin fees, you know, then you couldn't. So on the public housing financial assistance side, it's about how, you know, what funds they're paid with versus, you know, just strictly construction related labor on the housing community development side.
So meaning that if they were paid with op fund, we could count them, even if they don't actually work on maintenance?
If it's this operations and management assistance provided pursuant to 9E of the 1937 Act, then yes.
Oh,
It's
okay.
related to the contract, right?
If we go to slide 44 in day 1, which I'm trying to get us there.
I gotcha.
So because there's no threshold, all of your public housing activities or assistance that are in these categories are going to count. And so anybody that's being paid out of that is part of that project essentially. And so, yeah, they would count. The other thing I would just note that's on the HCD end of this, and let's use the example of a home funded project. You may have, let's say you're, I don't know, you've got a multifamily development and you have a staff person who's going to be charged off to that project as part of project delivery costs. And they're going to be, you know, looking at specifications or doing inspections on behalf for that project. Because they're charged off to the project, then they're part of this, and if they qualify, then their hours could be tracked and counted towards meeting those benchmarks. But if that same worker, instead of you're tracking their time and charging it off to the project delivery, if you're charging them to admin, then they're not part of that project, and so their hours couldn't be counted. So, you know, I guess following the money essentially on how people are being paid determines whether it's a labor hour that's part of that. So even in thinking about what are the total labor hours for that project, or for the case of PHAs where you're reporting on an annual basis, it's going to be all the labor hours that are paid for that project or fund.
Okay, so if they were, so what if the staff is paid with CDBG funding?
If it's chargeable to a Section 3 project where there's more than $200,000 of HCD assistance in that project, and it's all of their work is related to it, so like Les said, project delivery, then you could include their time. But if it's, you know, admin and it's just spread generally, then you couldn't. So it's the answer is both.
So for a public housing staff person who is paid for, whose salary is paid by CDBG funding, we can't put it in that pile of the previous slide where we could count anyone on the public housing side, because Les was saying specifically, or you were also, that was operating fund and capital fund. So operating fund, cap fund, those are both on the PHA. If anybody gets paid with that, it doesn't matter whether they work on the rehab or maintenance or not. We could count anyone paid whose salary is paid with those funds. And then we have the we've got some public housing, we've got multiple funding paying some of the staff at the PHA and for Section 8, such as CDBG, paying for navigators and housing counselors and whatnot. So for the CDBG funding paying for the PHA staff, we can't count them because that funding is coming from the CPD side. So therefore we follow the fundings. We follow the funding rules. So that's the CDBG, which would be the over 200,000. It would have to be tied directly to the project.
Right.
Is that correct?
Right.
We couldn't
Yeah.
count that employee if they were totally paid by CDBG, but working for the Public Housing Authority. We can't count that on the Public Housing Authority.
Right.
side.
They would have to be working on a project.
Okay.
On,
All right.
on the CDBG side. Yeah.
Thanks so much. That was this was all really helpful.
Good. Good. All right. Who's next? Medora.
Right. We've got Leanne Lawrence next. Leanne, I am about to unmute you. All right, Leanne, you have been unmuted. Leanne, we're having a bit of trouble hearing you. Are you using a headset right now? You may have to move your microphone up a little bit. Leanne, we're still having difficulty hearing you.
Now.
It's getting a little bit better.
Oh.
Leanne, I will troubleshoot with you in the chat and I will keep you at the top of the queue so you can go next. For the time being, I am going to unmute Hema Steele next.
Hi, thank you so much for all the information. This is really helpful. So somebody made reference earlier to LCP Tracker, and we think we've got a pretty good handle on being able to track Section 3 labor hours through LCP Tracker for all Davis-Bacon projects. So obviously that's things that are more than $2,000 and that are construction, rehab, remodel, etc. What we are really struggling with as a large PHA is what do we do about the things that are not subject to Davis-Bacon? And for example, looking at purchase orders and contracts under $2,000, and we had our purchasing department run those numbers for us. And in 2021, we had more than 8,000 separate purchase orders involving services, not just goods. And of course, those are all small contracts that are most likely being worked by Section 3 workers and or Section 3 businesses. So I guess what I'm looking for is some guidance, or I'm just wondering if HUD took into consideration by having like no limits on, that it's every PHA dollar. Like how do we wrap our heads around that and get these smaller businesses that don't use LCP Tracker or don't typically submit certified payrolls, like how do we capture all of those labor hours?
I think that's a tough question, and I'm assuming they're paid with these the funding sources listed here on the left.
Correct.
Okay, yeah. So I think I had a similar question because when I was working, there were bigger projects, but Davis-Bacon isn't triggered by on every single project. There are funding sources, like home, for instance, where you're not going to have Davis-Bacon necessarily. Often we didn't, and but Section 3 would still be triggered. So I think you're going to have to come up with a process. I don't know that I haven't seen, and Andalyn or Les speak up, any tools necessarily for really small contracts, but from everything we've read in the rule and understand from HUD, it is going to apply to anything covered by or paid for with the funding sources listed here. So go ahead, Les, if you have a suggestion.
When my head appears on your screen, I've
Yeah.
got something to add. So, I mean, I don't think there's an easy out on this. I do think that you know, you're required to document that you made your best efforts to try to meet the goals of Section 3. So, you know, by including standard language, I think a lot of folks will have a Section 3 plan, even though it's not required, which lays out a lot of information about what you expect those vendors to attempt to do as far as you know, identifying workers, that sort of thing. But keep in mind that even if you don't meet the quantitative benchmark, so if you can't, you don't hit the 25% of the labor hours being worked by a Section 3 worker, you still can qualify as being in safe harbor or being in compliance by being able to demonstrate that those qualitative efforts were done. So by having you know, a standard protocol at all those vendors, when there's a training or hiring opportunity, when there is a contracting opportunity for goods, that they would follow, you know, some of your steps on standard outreach. That might be simply as, you know, okay, if I have a job that's going to be available, I'm going to post it in the opportunity portal. I'm going to link with, you know, one of your ongoing efforts, so that you then have this document trail to say, okay, I am going to meet the qualitative effort end of this and be able to be in safe harbor. I mean, I would think particularly where you are, you know, the nature of some of what you're probably paying for in those small contracts, it may be very difficult. And we're certainly hearing this from folks who, based on you know, standard sort of salaries and costs of labor in their area, are looking at these things and saying, we're gonna have a really hard time meeting this. So you're needing to document that you made efforts, and then kind of your fallback is, I want to be able to show that I made those qualitative efforts on outreach and creating those linkages. And that's going to be the way I'm going to be sure that at the end of the day, no matter how the numbers turn out, that I'm going to be in compliance.
Thanks, Les.
And I'll just mention, we've had a couple of folks saying that have apparently looked. It appears that only the slides for the first session are actually posted. We'll check on what the status. I thought they were all posted by now, but I would just, you obviously have found the right place since you found the first set of slides, and the next slide should be coming soon. They have to go through some accessibility modifications before they can be posted. So I presume that they are close to being posted, and we'll check on that.
I made a note as well. Thanks, Les. Okay, Hema, did you have anything else? Is she still?
All right. All right, I think Hema may have disconnected.
Okay.
Majora, were we able to get Leanne online?
It seems like Leanne is having some technical difficulties. We're still troubleshooting. So for the time being, I can unmute Dina again.
Okay.
Okay.
There you go, Dina.
Thank you. I just wanted to mention briefly, we are also a large PHA, both county and city, and CDBG. We use eComply for our labor compliance program, and they also have a non-prevailing wage hour collection capability. So that's what we're using for all of our contracts to track Section 3 hours, so our Section 3 coordinator is able to go in and run reports when he needs to, and not have to wait for our different vendors and contractors to report their hours to us. But we have all the hours right there, and we can run the reports. So eComply has a great Section 3 portal section part and the reports, but also for non-prevailing wage projects as well.
Thank you.
Sounds like a great resource. I will just mention that I think based on, you know, the project and who the developer or contractor is, in some cases, you can put the burden on the contractor to say, this is what I need you to report and when. We've had a lot of discussions with folks who are kind of overwhelmed with thinking about tracking the Section 3 and targeted Section 3 hours for each workers. In some cases, it's going to be a reasonable thing to ask that employer to collect that and provide that to you. So I think to some extent, based on the project, based on the capacity of those other partners, that you can kind of make a decision how much you're going to have to do internally versus they provide that report to you and you maybe review it to try to determine, does this look reasonable and correct?
Thank you, Larry.
Okay. Got just a few minutes left. So who's up next? Medora.
All right, we have Lisa Roger next. Lisa, I'm about to unmute you. All right, Lisa, you've been unmuted.
Thank you. I'm with the Norwalk, Connecticut Housing Authority. And could you please confirm for me that Section 3 also applies to the Housing Authority's central office staff? So for instance, occupancy specialists, admins, inspectors, maintenance folks, finance, whatever. And if that's the case, our HR department should be able to determine if that employee is Section 3 based on their annual salary alone.
That's right. So it's how they're paid. So if they're paid with one of those sources, can we find that slide again, Andolyn? Then it would apply to them. And I had a long conversation about this early on when we read the rule, and it sort of blew my mind that it's not just construction work on the PHA side. It is anyone who is paid with these sources. So so if they are paid with one of these, then you would count their hours, and yes, as their employer, you could certify them.
Perfect. Thank you so much.
All right, Medora, do we have anyone left in the queue? We have about 2 minutes left.
Nope, we made it through everyone for now. Actually, that's my apologies. Trina has one more question. Trina, you are about to be unmuted.
Thank you. Actually, one of my questions was answered in a Q&A. So I was wondering, that means there are other answers that's in this Q&A. Will I have access to these answers here or as well? Because I'm just by reading the responses in the Q&A, my question was answered. So if I have something else, it's probably already been answered, and I want to know if I can just have something to refer back to, say, oh yeah, someone else thought about this as well. That's
my understanding is that I don't think the chat or the answers from this are being posted, but what we are doing is collecting these, and then they are submitting essentially additional FAQs recommending that they be posted. And so I do think you'll see some of these added to the posted FAQs as a result.
Okay, so it sounds like I'm the last one. You guys did a great job. I really appreciate this because it gave me something to think about as well.
Oh, good. Thank you. If you wanted to ask your question, even if it's in there, you're welcome to.
It was in regards to the HAP agreements. It's kind of confusing because when they come into the PHA, we don't really have a contract with them per se. So during a development process, should we pursue Section 3 compliance for them? It looks like it was answered saying, yeah, if it's any development, of course, any kind of rehabs and developments on that.
Right. Yeah. So if there's funds in the project that are here on the left side of the screen, then you would want to make sure that Section 3 was included and applied to anyone working on that project. But if it's just project-based vouchers, for instance, then that does not by itself trigger Section 3.
Thank you very much. Oh, when you say misfinanced development, anything that has government money in it, that's all that really means. If it has $1 of anything that's coming from the government, that means it will kick in.
So it says as described in 24 CFR 905.604. So it would be specific to that, to a project, a mixed finance development project described there.
Okay, thank you. I think
and I will just mention there is a Section 3 training series that is being looked at for, I think, starting in May, that will be specific for PHA financial assistance. And I'm hoping that as part of the developing that some of this will dive a bit deeper and give you and us some better answers to some of these PHA specific questions. So keep an eye out for marketing information about that, because it sounds like that'll be helpful to quite a number of you.
Yes, thank you.
Thank you.
Thank you. All right. I think, so we're at time. So thank you everyone for joining us. Anyone else have any parting words or wisdom?
We hope this was helpful.
Yeah.
And we'll check on a couple of these things that you've asked us about.
Yep. Thanks.
Thanks, everybody.
Thank you, everybody.